Post-World War I, in 1921 and 1922, the highest German court, the Reichsgericht, put 17 Germans on trial for suspected war crimes during the war. Per the original Treaty of Versailles, the Allied powers wanted these war criminals extradited so they could be tried in Allied courts. But the German government succeeded in preventing their extradition. The trials turned out to be a sham, with minor sentences being meted out to the accused. But it taught an important lesson to the Allies, which they kept in mind at the conclusion of World War II. War criminals could not be tried in local courts. The Nuremberg and Tokyo Trials post-World War II were a direct result of this conclusion. Welcome to The Why in History. I am Ajay Kaul, and today we take a look at the prosecution of World War II war criminals via the Nuremberg and Tokyo Trials. In the months leading up to the Allied victory, voices calling for vengeance had been numerous and forceful. As the war in Europe started winding down, Allied leaders began to address what should be done with the Nazis. At the Yalta Conference in February of 1945, British Prime Minister Winston Churchill favored swift executions of top Nazi leaders. Soviet leader Joseph Stalin preferred slow trials, followed quickly by mass executions. US President FDR, with his health failing badly, was hearing conflicting opinions from his cabinet. Roosevelt's influential Treasury Secretary, Henry Morgenthau, who was Jewish and enraged by Nazi atrocities, argued for the summary executions of those he called the arch criminals of this war. But FDR's Secretary of War, Henry Stimson, was adamant that Nazi leaders be put on trial. According to Stimson, the punishment of these men in a dignified manner will have all the greater effect upon posterity. Subsequently, Stimson advanced a plan developed by a young Jewish lawyer on his staff, Murray Bernays, to try Nazi leaders as a criminal conspiracy, like an organized crime syndicate. According to Henry Bernays, the atrocities were not single or unconnected, but were the inevitable outcome of a conspiracy based on the Nazi doctrine of racism and totalitarianism. Subsequently, on August 8, 1945, the London Agreement was signed by the United States, Great Britain, France, and the Soviet Union, which established the International Military Tribunal, or the IMT, to prosecute and punish major war criminals in the European War. The agreement codified crimes such as waging a war of aggression, war crimes, and crimes against humanity, making individuals responsible for these actions punishable under international law for the first time in human history. Essentially, the London Agreement laid the foundation for an international court of justice for trying individuals accused of war crimes. Each of the four signatory countries were expected to nominate a primary and a standby for the judges conducting the trial. So from the United Kingdom, Sir Geoffrey Lawrence and Sir Norman Burkitt were nominated. The United States nominated Francis Biddle and John J. Parker. France sent Henri Dorigny and Robert Falco, and the Soviets sent Iona Nikitchenko and Alexander Volskov. Towards the closing days of the war, many Nazi leaders committed suicide to avoid capture and trial, but several of them actually fell into Allied hands either through surrender or capture. And prominent among them were Deputy Führer Rudolf Hess, who had been in England since 1941 when he had parachuted into the Scottish sky in an effort to convince British leaders to make peace with the Nazi government. However, the prize catch was Hermann Göring, Hitler's close confidant and the primary architect of the Nazi police state in Germany. On November 20, 1945, Hermann Göring, Rudolf Hess, and German Navy Admiral Karl Dönitz, along with 18 other Nazi leaders, stepped into Nuremberg's Hall of Justice to be tried for World War II war crimes. The prosecution team was led by U.S. Supreme Court Justice Robert Jackson. Jackson was determined that the Nazis pay for their crimes, but he was also fearful that Hitler's henchmen could use this high-profile forum to reignite Nazism in Germany. So on November 20, 1945, 500 spectators, 21 Nazi defendants, the prosecution team, the judges, news reporters and cameramen filled the Hall of Justice for the start of the trial. One interesting point to note is that the prosecution ensured that none of the defendants were still serving in the German military, and this was because they were being tried as leaders of the German government rather than prisoners of war. Chief Prosecutor Robert Jackson started the trial with his opening argument, which said, "The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility." He went on to state, "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated." The prosecutors sought to prove Nazi Germany's crimes through the words and testimony of the Germans themselves. They based their cases primarily on thousands of German documents seized by the Allies, and most of the witnesses called to testify had been members of the Nazi Party, the SS, the German state, or the military. In fact, there was so much evidence that Prosecutor Jackson is said to have remarked, "I did not think men would ever be so foolish as to put in writing some of the things that the Germans did." During one of the days early in the trial, Prosecutor Jackson projected a film made from clips of German propaganda. It showed how the Nazis had systematically violated treaties, rearmed Germany, and attacked neighboring countries with the criminal intent to subjugate and pillage them. When the lights came back up, Hermann Göring was ecstatic, and he commented that they don't have to show films to prove that we rearmed for war. Of course we rearmed. I rearmed Germany until we bristled. However, Hermann Göring's mood changed significantly when the next film was shown as evidence of crimes against humanity. And this film was about the Dachau Nazi prison camp. It showed clearly the shower bath, and inside the shower bath, the gas vents, and on the ceiling, the dummy shower heads and cyanide powder, which was used to mass poison the inmates. And all of a sudden, a lot of the Nazis on trial began to cry. Not for the Jews they had killed, but because they realized that their fate was now sealed and there was no way to escape execution. The most damning evidence against Hermann Göring, though, was a document from July 1941 authorizing the final solution to the Jewish question. That is, the systematic murder of all of European Jews. On January 3, 1946, the prosecutors called SS officer Dieter Wisliceny to the stand. Wisliceny described how in wake of Göring's order, he had helped to organize deportation of Jews to the extermination camps, where all of them had been killed, except about 25 to 30% that were used for labor purposes. Also in January of 1946, a series of concentration camp victims testified about their experiences. And these experiences included Nazi orchestra playing happy tunes as soldiers separated those destined for slave labor from those that would be gassed. The prosecution rested on March 6, 1946, after 33 witnesses and hundreds of exhibits had been produced. It was now time for the defense to present its case. Hermann Göring took his seat in the witness chair wearing a gray uniform and yellow boots, and his defense attorney, Otto Stammer, asked whether the Nazi Party had come to power through legal means. And Göring told the courts, once we came to power, we were determined to hold on to it under all circumstances. Göring did not evade any questions, nor did he offer any apologies. He testified that the concentration camps were necessary to preserve order. It was a question of removing danger, and the leadership principle, which concentrated all power in the Führer, was the same principle on which the Catholic Church and the government of the USSR are based, according to Göring. Subsequently, during his cross-examination by Robert Jackson, Göring admitted that he had made the quote, "I would not like to be a Jew in Germany." There were a few defendants, though, who confessed to their crimes and apologized. Wilhelm Keitel regretted giving orders for the conduct of war in the East, which were contrary to accepted usage of war. Hans Frank, the Nazi governor of Poland, answered yes when asked whether he ever participated in the annihilation of Jews. He stated, "My conscience does not allow me to simply throw the responsibility simply on minor people. 1,000 years will pass, and still Germany's guilt will not have been erased." However, the most willing of all defendants to accept blame was Albert Speer, the Minister of Armaments. He said to the courts, "This war has brought an inconceivable catastrophe. Therefore, it is my unquestionable duty to assume my share of responsibility for the disaster of the German people." The Nuremberg trial hearings ended on September 1, 1946. And a month later, on October 1, 1946, the judges delivered their verdict. 19 of the defendants were convicted and 3 were acquitted. 12 defendants were sentenced to death, including Hermann Göring and Martin Bormann. On October 16, 1946, 10 of the condemned were hanged and cremated in Dachau. Their ashes were subsequently dropped in the Isar River. Hermann Göring escaped the hangman's noose by committing suicide the night before after he mysteriously got access to a cyanide pill. Martin Bormann, who was convicted in absentia, was later proved to have died in Berlin during the final days of the war. On October 6, 1945, subsequent to Japan's surrender during World War II, the commander of the Allied forces in the Far East, General Douglas MacArthur, received a directive granting him authority to proceed with major trials in the Far East. Trials to try the war criminals of the war in the Pacific. Following the same guideline that was being followed at Nuremberg, the trials would be conducted under 3 broad categories. Crimes against peace, under which Japan's top leaders who planned and directed the war would be charged, and conventional war crimes and crimes against humanity, under which any Japanese civil or military personnel could be charged. These trials came to be known as the Tokyo Trials. In stark contrast to the Nuremberg trials, the Tokyo Trials had 11 judges on the panel. 1 judge each from a country that participated in the Pacific War. Led by Sir William Webb from Australia, the other judges included jurists from China, New Zealand, Great Britain, the Netherlands, France, the United States, Soviet Union, Canada, the Philippines, and India. Both Philippines and India had participated in the war in the Pacific and lobbied heavily with the International Military Tribunal of the Far East to have representation of their respective countries. So Radha Binod Pal sat on the bench representing India, and Delfin Jaranila represented the Philippines. Another area where the Tokyo trials differed from the Nuremberg ones was that most of the Japanese civil and military leaders who led the war were alive. So the primary question before the tribunal was if Emperor Hirohito was going to be tried. But General Douglas MacArthur, commander of the Allied forces in the Far East, sent strict instructions to the tribunal that Emperor Hirohito was not to be tried. And as a result, the highest military leader on trial was Japan's wartime Prime Minister, Hideki Tojo. Incidentally, Tojo had tried to commit suicide by shooting himself in the chest after Japan's surrender. But he was saved by the American doctors and was ready to stand trial. So on May the 3rd, 1946, 9 judges from the International Military Tribunal for the Far East occupied the bench to try 28 Japanese defendants for crimes against peace, conventional war crimes, and crimes against humanity. Wait, 9 judges? Weren't there supposed to be 11? Yes, but 2 of the late additions, Radha Binod Pal from India and Delfin Jaranila from the Philippines, had not had enough time to join the panel at the start of the trial. So the trial started without them, and they joined the panel a few weeks later. The first day of the trial was quite dramatic and comical. Shumei Okawa, one of the defendants, who was charged with plotting the Mukden incident in 1931 that led to the Japanese war against China, started getting a little fidgety, even tried to strip, but was stopped by the military police behind him, and then leaned forward and slapped Hideki Tojo on the head. Okawa was subsequently removed from the proceedings and subjected to psychiatric examination. He never returned to the trial after that. On the judgment front, the trial did not go off to a good start, and an element of hypocrisy was very visible, which did not sit well with some of the judges. By element of hypocrisy, I mean one of the countries represented on the tribunal, the Netherlands, had engaged in a full-blown invasion of the Dutch East Indies after Indonesia had declared independence on August 17, 1945. Similarly, the US bombing of Hiroshima and Nagasaki was another contentious issue that reeked of hypocrisy in the eyes of the judges. So within less than a month, the American judge John P. Higgins resigned his position, citing his desire to return to his family and his permanent role on the Massachusetts Supreme Court. After Higgins's departure, Major General Myron C. Kramer, a former judge and advocate general of the U.S. Army, was appointed to serve as the new American judge. Also unknown to the panel was that Filipino judge Jaranila was himself a Japanese prisoner of war and had been part of the infamous Bataan Death March of April 1942. So among the jurists on the panel was a judge who should have technically recused himself. Now, while the Tokyo trials were going on, the Nuremberg judgment came out and it set a legal precedent. A nation's political and military leaders were personally responsible for waging a war. Meanwhile, the Tokyo trial continued to drag on, and many observers felt it was primarily because the Chief Justice Webb did not have much control over the proceedings. By the beginning of 1947, the defense stage of the trial began, and by September of 1947, the defendants started taking the stand to testify. Though the defendants were extremely particular about maintaining the innocence of Emperor Hirohito, there were slip-ups where some important information would get revealed. Like during the testimony of Minister for Foreign Affairs, Shigenori Togo, it was revealed that the emperor had dressed himself in full naval uniform during the Japanese attack on Pearl Harbor, indicating that the emperor was fully aware. But the only time during the trial when there was significant interest was when wartime Prime Minister Hideki Tojo took the stand on December 26, 1947. While taking full responsibility for the war, Tojo maintained that the war was an act of self-defense against the strangulation of Japan by the United States and the United Kingdom. During the course of his testimony, though, Hideki Tojo dropped a massive bombshell. He asserted that the emperor had fully consented to the war and none of us dare act against his will. There was shock and a pin-drop silence in the courtroom. But Chief Justice Webb had finally got what he had been looking for. He promptly wrote to General Douglas MacArthur to bring the emperor in for questioning. General MacArthur, though, was not going to let that happen. He pulled his strings, and Tojo was instructed to carefully recant his statement, and he also clearly told Chief Justice Webb that the emperor was not going to take the stand. So why did the United States go out of their way to protect the emperor? The official justification was that the US did not want to displease the Japanese public by prosecuting or removing their emperor. But in reality, the Japanese were more concerned at that time with food and housing crises than the status of their emperor. The real reason seems to have been that the US was looking at Japan to become a key ally in that region to maintain the balance of power. And a weakened and grateful emperor would play a crucial role in transition of this wartime foe into a long-term ally. Finally, on November 4, 1948, after more than 2 years, the judges at the Tokyo Trials pronounced their sentences. 25 of the 28 Japanese defendants were found guilty. Of the remaining 3, 2 had died during the lengthy trial, and the third, Shumei Okawa, who slapped Hideki Tojo on the head during the trial, was declared insane. 7 of those found guilty were given the death sentence, including General Hideki Tojo. 16 were sentenced to life imprisonment, and the rest were sentenced to lesser terms in prison. On December 23, 1948, Hideki Tojo and the 6 others were executed in Tokyo. Across the 11 judges, there were several dissenting opinions, with Chief Justice William Webb expressing his displeasure that the emperor could not be prosecuted. Other justices, such as Henri Bernard of France and Bert Rolling of the Netherlands, also expressed displeasure and concerns about procedural issues during the trial. However, a massive dissenting opinion came from Radha Binod Pal of India, who argued that the crimes against peace and crimes against humanity were applied post facto, that is, after they occurred. And he further argued that if that were the case, then the colonial powers too should have been prosecuted. And on that note, we end this section of the program. On to the quiz section. Question from the previous episode. The Gini coefficient is a statistical measure of wealth distribution and is used to gauge economic inequality by measuring wealth distribution. Based on the 2025 Gini coefficient, which countries display the highest wealth inequality? According to the 2025 Gini Index ratings, South Africa, Namibia, and Colombia are the 3 most unequal countries. So the answer is D, South Africa, Namibia, and Colombia. Question for the current episode. Which suspected World War II Class A war criminal went on to become the Prime Minister of their country? Was it A, Germany's Erich Raeder, B, Japan's Nobusuke Kishi, C, Japan's Matsutaro Shoreki, or D, Germany's Franz von Papen? Once again, which suspected World War II Class A war criminal, went on to become the Prime Minister of their country? Was it A. Germany's Erich Raeder, B. Japan's Nobusuke Kishi, C. Japan's Matsutaro Shoriki, or D. Germany's Franz von Papen? The answer will be provided in the next episode. That's all we have in the current episode. We meet again in 2 weeks with another interesting and exciting episode on world history. Till then, stay safe and keep exploring the why in history.